Welcome to this edition of the Housing Ombudsman Service Casework Conversations podcast. I'm Victoria King, one of the sector learning and development leads here at the Housing Ombudsman Service. And today I'm joined by Shelley Power, a dispute resolution manager in one of our dispute resolution teams. Shelley's just stepped up into the role of manager from an adjudicator, and today we're going to be talking about a case that Shelley worked on as an adjudicator. So first up, hello, Shelley. Welcome to this edition of the Housing Ombudsman Service Casework Conversations podcast. That's a mouthful. Could you just tell us a bit about you, what dispute resolution adjudicator does at the Housing Ombudsman Service, and what your team does as well?
Yeah, hi Victoria. I'm Shelley Power, and I've been an adjudicator since January 2023. And as you said, I've recently took on the acting up position of a dispute resolution manager. So the dispute resolution teams investigate cases brought to the Ombudsman to decide whether the landlord has acted fairly in resolving a resident's complaint. Cases are allocated to adjudicators to consider all the evidence provided by the landlord and the resident. And then once the investigation is complete, a decision is issued on behalf of the Ombudsman. And this will explain whether we found any failings, or it may say that we found no failings. In cases where we have found failing, we'll explain what the landlord needs to do to put it right.
Thank you, Shelley. So we're here to talk about a case you determined which involved a large housing association landlord, and this case related to service charges. And we're talking about this case today because whilst the landlord didn't handle the case particularly well, and we found maladministration, it did respond well once we had investigated and determined the case. So could you give us a bit of a background of what happened in the situation, a little bit about the resident and a bit about the complaint as well?
Yes, so the resident was an assured tenant of a 3-bedroom house, and she moved into the property via a mutual exchange in November 2013. She said that she'd been complaining to the landlord for quite some time about paying a service charge for a service that she didn't receive. So she raised a complaint in July 2022, asking the landlord to remove the charge and refund her from when she moved into the property.
So the resident had been disputing her grounds maintenance service charge for a few years, and she wanted those charges removed. And she eventually complained, and the landlord responded. What did the landlord say in that response to her complaint?
So the landlord initially sent a stage 1 complaint response in August 2022, but we didn't actually see a copy of that. It later wrote to the resident in April 23, acknowledging that she didn't receive a grounds maintenance service. It apologised for the error, and it actually refunded £425. This was 6 years of charges, which it said was in accordance with the Limitation Act. The resident was unhappy with its response and asked the landlord to escalate her complaint to stage 2. She again asked for the service charge to be refunded from when she moved into the property and asked for a revised rent account statement. She said that she'd checked with a neighbour who told her that he didn't pay a service charge, and she also said that the council were responsible for her road. So the landlord responded at stage 2 of its complaints process in October 2023. It acknowledged that her road was not part of the estate and that the council was responsible for any maintenance. It repeated its stage 1 response that it refunded her the £425, and it apologised for its poor communication and complaint handling and offered a further £280 compensation.
So the resident was unhappy with the landlord's response, and she brought her complaint to us. And to resolve the complaint, she wanted the landlord to refund the service charge from November 2013, pay interest, and provide an up-to-date statement. When you investigated the case, what did you find in relation to the service charge refund?
So when we're investigating a case, we look at a number of documents such as the tenancy agreement, the landlord's policies and procedures. The landlord's service charge policy stated that service charges are collected from residents who receive services, such as for the upkeep of maintenance and communal areas around their home. Tenancy agreements set out what services can be charged for and for within the relevant estate. Service charge terms and practices must be fair, and legal rules on consumer protection apply to service charge provisions. This means that tenancy terms which allow the landlord to claim a charge without providing the service, or where the landlord's entitled to decide if the service has been provided, could be unfair and not enforceable. So we must decide what's fair in all the circumstances under the Housing Act 1996 and the Housing Ombudsman Scheme. As a matter of fairness, service charges will only be payable where the service charge is chargeable under the terms and conditions of the tenancy, and where the landlord can demonstrate that the residents received a service or benefited from a service. So in this case, we didn't have sight of the original tenancy agreement, only the assignment paperwork from the mutual exchange. It referred to weekly rent, but it didn't specify any charges at all for services. The evidence showed that the resident made multiple inquiries about the service charge over a prolonged period of time, and the landlord's responses were often delayed and contradictory. The landlord appropriately acknowledged its error in charging for the grounds maintenance and apologised, and it did refund 6 years' worth of charges. It also removed the charge for any future months, but it failed to consider any distress or inconvenience caused to the resident, something which she'd been reporting was causing her stress. Its application of the Limitation Act was also not reasonable in this case. Given that it wholly acknowledged its error, it should have refunded the charges from when the resident moved into the property. So despite the resident's repeat of her complaint in a escalation request and further explanations, the landlord's final response was a repeat of its earlier response. It didn't demonstrate that it gave any further consideration to the matter.
So what was your finding then after you looked at all of the evidence in relation to the request for that service charge refund?
We determined that the landlord acted unfairly by charging the resident for grounds maintenance, a service that she didn't receive. It also acted unfairly in the way that it handled her issues, often delaying responses and providing conflicting information. And its application of the Limitation Act was also unfair. So for these reasons, we made a finding of maladministration.
And you also investigated the landlord's complaint handling. Can you summarise what you looked at in relation to that?
So we looked at whether the landlord had responded within its complaint policy timescales and in line with our complaint handling code. It responded within 10 working days at stage 1, which was in line with its policy timescale. But the resident had to chase the landlord to escalate her complaint on multiple occasions. Its final response was also 91 working days later than its 20 working day timescale.
So what was your finding then after considering all of the evidence in relation to the complaint handling?
We actually made a finding of reasonable redress. This was because the landlord acknowledged its complaint handling failures, apologised and offered £280 compensation, which was in line with our remedies guidance.
So just to summarise then, you found maladministration in the landlord's handling of the request for a service charge refund from November 2013, and you found reasonable redress for the complaint handling because the landlord had made that offer of redress prior to your investigation, which satisfactorily resolved the complaint handling issues. What orders did you make in this case?
So we ordered the landlord to pay the resident £250 to recognise the distress and inconvenience she'd experienced in chasing her complaint and getting a resolution. We also ordered it to refund the service charge dating back to the start of the tenancy, plus 2% interest, which was the average RPI. That was to consider that the landlord had benefited from the money when the resident was not able to. We also ordered the landlord to no longer claim for the charge of grounds maintenance and to provide an up-to-date statement and breakdown of any other charges. And we ordered it to send a further apology.
So just going to jog and bust RPI there. That's retail price index.
Yes.
So the orders the landlord has to comply with. So the orders the landlord has to comply with and the recommendations they should comply with. What did you make with regards to recommendations?
Yeah, so our finding of reasonable redress for complaint handling was made on the basis that it pay the £280 offered in its stage 2 response if it hadn't already paid it. We couldn't make any wider orders for the landlord to consider whether it was appropriately charging other residents on the estate. And while our recommendations are not binding, we did make a recommendation that it consider this.
So I mentioned at the beginning that we're talking about this case because there's some learning that we want to share with others, particularly in the landlord's response once we had determined the case. Can you tell us what happened after you determined the case and you'd made those orders and recommendations?
Yeah, so when we received the landlord's compliance evidence with the orders, it told us that it had identified 38 other residents that it was incorrectly charging. It explained that it was in the process of working with its service charge team to resolve this. So by determining this one case, 39 residents benefited from refunds of service charges that they shouldn't have been paying.
So if this case were to happen again, maybe there's a landlord listening who has one similar or that's just been determined by us or about to be, what key headline things did the landlord do in this case that was so exceptional?
So I think in this case, it's a really great example of the landlord looking beyond this individual case itself and finding out if other residents have been impacted by the same issue and then doing something to rectify the issue for those residents too.
Thank you so much for your time today, Shelley, and thank you to those who have listened to this podcast. You can find out more about our decisions on our website at www.housing-ombudsman.org.uk. And if you're a member landlord of the Housing Ombudsman scheme, you can also get exclusive access to our Centre for Learning Landlord Hub, details of which you can also find on our website. Thank you very much for listening. Bye.